questions. You may not use electronic devices in the audience for any reason. However, you may use an electronic device at the podium if it's going to assist you in your argument. You may not eat or drink in the audience. However, you may drink water at the podium if it's done at the podium. You must keep your mask on at all times in the courthouse. And you may remove it if you have the white visitor sticker at the podium during your argument. When you go back to your seats, please go back to your mask on. Thank you. Council, you got 30 seconds on your laptop, please. We're about to open up. Please have a seat. Please rise. The Justices of the Appellate Division, Supreme Court, First Department. Hear ye, hear ye, all persons having business with the Appellate Division. Draw near, give your attendance, and you shall be heard. Please be seated.
Welcome to the Appellate Division, First Department. We have over 7 hours of argument time requested, so only ask for the time that you need. We have read your briefs and the records, and we are familiar with the cases. The first case is People versus Brown. Petitioner? Okay, that is submitted. Davis versus Graham Court Owners? Submitted. Kimona is submitted. Dabrowski versus ABAX Incorporated, appellant. Respondent? I will give you 5, 1, and 5. Verrier versus Robledo, appellant. Okay, that is submitted. People versus Green, appellant. Submitted. Nobody wanted to come out in the rain. Brook versus Peconic Bay, and Judge Carpula is recused in that. Okay, and respondent? Okay, I'm going to give 4 minutes for the corporate appellant and 1 minute of rebuttal and 2 minutes for the individual appellant and 1 minute of rebuttal, and I will give 6 minutes for the respondent. Lorenzo versus Great Performances, appellant. Respondent? 5, 1, and 5. Bracco versus Eastern Metal, appellant. Respondent, Eastern Metal. And respondent, Port Authority. Okay, I'm going to give you 5 and 1 for appellant and 5 minutes for each respondent. People versus Perez Castellanos, appellant. Respondent? I'll give you 6, 1, and 5. Vrapi versus Dashmir is submitted. Prime Property versus Imperial Transport, appellant. I see 3 people standing up. I didn't see that you requested time in your brief. What? Okay, and did you request time? You did? Okay, and how much time are you requesting? Okay, 5, 1, 5, 4, and 2. Shevlin versus Wonderworks, appellant. I'm sorry, what'd you say? Respondent? 5, 1, and 5. People versus Morales is submitted. Etage Real Estate versus Stern, appellant. Are you the appellant on it? Do you want to submit or do you want to? Okay, I'll give you 3 minutes, okay? People versus Fuller, appellant. That is submitted. Odeker versus Hudson River Park, appellant. Okay, submitted. General Insurance versus Piquian, appellant. Do you still want to argue? I'll give you 3 minutes. People versus Harris, appellant. Okay, that is submitted. And Lindsay versus CG Maiden is submitted. So the first case on is People versus Brown. Oh, I'm sorry, People versus Brown is submitted. Dabrowski versus ABAX Incorporated. Go ahead.
Good afternoon. May it please the court. My name is LaDonna Lusher, Virginia Ambinder, and I represent the plaintiffs' appellants in this matter. The appellants are respectfully requesting that this court overturn the trial court's order because it impermissibly dismisses the claims of an absent class member. And it also essentially sets up a mechanism for any defendant in any class action to send out deposition notices to absent class members and then seek to dismiss their claims.
Has there been any communication or involvement from this class member?
There has not, Your Honor. Mr. Nardowick has not responded. We've never had any contact with him. And in fact, it's interesting because he was actually the subject of a motion to dismiss previously that the trial court denied, and this court actually affirmed that, finding that he...
Counsel, wasn't that situation totally distinguishable, though? Because in that case, he had only failed to appear once, when now it's 15 years and he's failed to appear a multitude of times. So why would that prior decision have any impact on what we do now?
It does, Your Honor, because there is no new evidence to show that that anything is different, that the situation.
Well, isn't that when we're assessing whether something's willful or contumacious, isn't failing to appear once less willful and contumacious than failing to appear repeated times?
For a party to a lawsuit, then the trial court could have found that. And that's the case law that the trial court relied on, but not for an absent class
Well, let
member.
me ask something. Was that an argument that you made clearly below to the court below, that this plaintiff should be treated differently because they were an absent class member, or are you raising it for the first time on appeal?
We've actually been making this argument since 2014. It wasn't as clear, admittedly, it wasn't as clear on the instant motion that's on appeal now. However, the defendants acknowledge in their reply, which is in the record on page 99, that we have consistently argued that absent class members are not subject to discovery and they shouldn't be subject to a harsh sanction of dismissing their claims.
Well, if you didn't make the argument below, why should we consider the argument now for the first time on appeal in this motion? I'm
happy to address that, Your Honor, because first of all, there are no new facts being raised here by our argument. It's simply a legal argument, and it's also because from the record, on the face of the record, and the trial court's decision compels us to make these arguments.
So, counsel, let me ask you, didn't you sign a stipulation in December 2016 agreeing to his deposition?
We signed a stipulation agreeing to the deposition
of him and to reserve the notices, and he was named Narcewicz, Peter Olachewski, and someone else, another three. And those people were named. You signed a stipulation. You said, yes, we will produce those people for depositions, reserve them. And now you're coming and saying he's an absent class member after you signed that stipulation, which was so ordered and is a court order now?
The stipulations in the record do not name the specific individuals. They say that deposition notices will be reserved on absent class members.
Was there any doubt that he was one of those people?
No, but
so, okay, you sign a stipulation saying, yes, we agree to produce him, and then you don't produce him. And now you're arguing to us on appeal for the first time that we should take a look at an issue of law which you didn't raise below and which contradicts the stipulation that you signed?
Respectfully, we did raise it below, and it was an issue before this court. And what we had stipulated to initially was for the deposition of 4 or 5 class members. The fight before Judge Silver was who was going to select these class members. The defendants won that fight. They selected Mr. Nardovich along with 3 other class members. 2 of those other class members also did nothing different than Mr. Nardovich. They didn't appear for their depositions. Their claims are still intact in this case. They did not receive their deposition notices, allegedly, and they did not contact class counsel. There's only 1 of those 4 that has actually been deposed, but yet Mr. Nardovich is being treated differently here. His claims are being dismissed.
What's wrong with serving a notice of deposition on absent class members, even if we were to consider the argument on the merits? What prohibits that?
Because absent class members are not subject to discovery under Article 9. Article 9 class actions are what are opt-out class actions, meaning that when the class is certified, everyone's included.
Is there a case which says you can never serve a deposition notice on an absent class member under any circumstances?
There are cases that we cite in our brief that say that absent class member discovery is generally prohibited. There are a handful of cases that allow it, but those cases are generally cases alleging fraud, and the defendants have demonstrated that they needed discovery from the absent class members to show their state of mind.
Counsel, I have another question. What efforts did counsel undertake to, obtain his appearance?
So we have never had any contact with Mr. Nardovich. We've never had any contact with the other 3 deponents that did not appear, the other 3 class members that were noticed to be deposed. We used the records that we had from discovery that contained his address, and we mailed the notices. Then we also conducted our own public records search to find updated addresses. At the end of the day, these notices were mailed to 3 different addresses, but Mr. Nardovich never contacted us, and there is no evidence in the record that he actually ever received the notice. Therefore,
Thank you. Thank you very much. You have time on rebuttal.
Thank you.
May I begin?
Go ahead.
Good afternoon. May it please the court. Nathaniel Newberger from Milliman Labuda Law Group, appearing on behalf of defendants, respondents. So I'd like to respond to some of the arguments that you just heard from.
Right. I'd like to ask you, why is this the one that you've picked? If there are others that have the other non or absent class members who have also not responded, you haven't sought to dismiss their claims. Why is this person the person?
Oh, absolutely. I'm happy to answer that. So initially, when the 4 that we had chosen failed to appear, as this court would recall, we did move to dismiss all 4 of them for failure to appear. And it came before this court. This honorable court said there's no evidence of repeat failure for them to appear. What the difference is between Mr. Nardowitz and the others is, number one, one of the 4 actually has appeared for a deposition. That's Mr. Olakowski. And then one of them, we're not sure what happened to him. He may no longer be alive, word on the street. And then the last one, we didn't get back this time around the signed certified mail receipt. That's the difference. Mr. Nardowitz, we have 2 signed certified mail receipts since the last time we moved to dismiss. And that's clearly willful and contumacious.
Why do you need his deposition testimony? What is so special about him? And you have
Well,
class representatives, right? Why do you need him?
Well, this group of people worked on what's called HPD work, Housing and Preservation Development. And one of the positions that we've taken in this litigation, and is hopefully going to be the subject of a motion to decertify the class action, is that HPD work is not public work. So what we were trying to do is get these people to come and testify about the nature of the work that they do and, file a dispositive motion. We're not at that stage yet. Hopefully we'll get to that. But that's why we wanted these particular people. We have since deposed several other people. We didn't hang, our hat just on these 4. We tried repeatedly to depose them. When we didn't get them, we got some other people. But again, the evidence is pretty overwhelming with Mr. Nardowitz that he got, there's a presumption of receipt of mail. We have at least 2 signed certified mail receipts, although plaintiff disputes that it's his signature. Again, no one's a professional handwriting analyst here, but the evidence is pretty clear.
Counsel,
Yes.
what about the argument that your adversary makes that absent class members would not be subject to Article 9, so we should be looking at them differently?
So the notion that absent class members aren't subject to discovery is an issue that's been waived by plaintiff. Justice Silver, back in 2013 and 2014, has repeatedly compelled the depositions of these particular members, including Mr. Nardowitz. Plaintiff could have appealed that. They didn't do anything of the kind. So they've clearly waived the issue to now, at the 11th hour, say these people weren't subject to discovery. That issue is not on the table. The only issue is whether or not the lower court acted in its discretion properly acted in its discretion in dismissing Mr. Nardowitz. And we say yes. The evidence is clear that Mr. Nardowitz failed to appear. Like I said, the presumption of receipt of mail is there, and plaintiff really can't rebut it at this point in time.
And do you know of any case law that says that this is discovery against non-appearing class members is prohibited?
So unfortunately, Your Honor, the case law, at least in New York State Court, is fairly limited on this issue. As
But
Your
there
Honor
are
has seen-
federal cases, right?
Right, there's lots of federal cases.
And in federal cases, it's generally permitted.
Yeah, well, we
Under some circumstances, right?
it's generally permitted to have discovery of absent class members. That's correct.
Absent.
Right.
Couldn't think of the word.
And like I said, the difference, Your Honor, here is that there is a court order, several court orders that permitted that ordered this person to appear.
And stipulations, correct? Stipulations by the
Correct.
parties.
Stipulations and court orders, Your Honor.
Okay. All right.
So, okay. And then with regard to just plaintiff's search, they said they conducted a public record search for Mr. Nardowitz. As class counsel, I would think they would try to be a little more aggressive in trying to find these people if they're having trouble locating them. I would think they could have hired a private investigator. I mean, they're supposed to zealously represent these class members, and I don't believe that they did so in this situation. Okay. And again, you touched upon before with Appellant about the fact that a lot of the arguments in their brief were not raised before the court below. I think they're taking a pretty expansive definition of what it means that an argument is made on the record on appeal. I mean, record on appeal means the record for this appeal, not any appeal or any motion before. Thank you.
Thank you very much.
Kludman versus Northern Leasing, New York State court case that says that absent class member is generally not permitted. I can give the court the citation for that if you'd like.
I mean, yes, but there are plenty of federal cases in the Southern District where a lot of these class actions are that allow class discovery, correct?
You're correct, Justice Scarpula, and I will tell you, though, that in those cases, generally there are FLSA claims, which are opt-in claims, meaning that in those cases, in order to participate, the class member has to file a consent to join form saying they willingly participate, and then they're a party plaintiff. That's different from an Article 9 class action under New York labor law, which is an opt-out class action, where everyone's automatically included unless they choose to opt out. So
Excuse me, who was harmed by Justice Kahn's order?
every class member that is ever going to be in any class action in New York State. Essentially, what this decision does is it allows a defendant in any class action to send out notices of deposition to class
So
members.
then why didn't you move below? Why did you sign stipulations saying, sure, depose them?
I'm happy that you asked that, because we were trying to evade more motion practice. This court can see we're up to motion number 28. It's 15 years old. We thought that we could work it out with the defendants, that we would agree to produce 4 or 5 class members. Looking back on the stipulation, we should have been more specific, but we thought we would have the opportunity to choose those individuals. They decided they were going to choose those individuals, and that's the fight that was in front of Judge Silver.
But isn't that usual? Isn't that the way it usually goes in discovery, right? The party who seeks the deposition is the one who gets to choose. I don't know why you would think that you could choose if that's not the way it normally goes. So, I mean, I just struggle with saying now on appeal, yeah, sure, we signed these steps and there were plenty of orders, but we didn't mean it, and yes, the person was served. I hear what you're saying, but is this the case to press it?
It absolutely is, and I know I'm out of time, but if I could just say one last thing. It absolutely is, because the circumstances, this order allows defendants to do this in every case.
No, you appeal. The next case, you object. You make a record. You don't say, sure, I'll produce them. That's a different situation.
But we never agreed to produce these 4 people, and regardless, even if they were, there's the harsh sanction of dismissing a class member's claims, particularly when other class members were also noticed for deposition and didn't appear, but they're allowed to participate in the recovery of the class action just simply because the defendant chose not to move to dismiss their claim. The defendants have...
Thank you.
Thank you.
Brook versus Peconic Bay. Oh, yes, Judge Scarpula is recused. Yes, you must step out. You dropped something.
Oh, thank
May it please the court, Your Honor, my name is William Thomas Schauer with the firm Pryor Cashman, representing the corporate plaintiff here, which is Adam Brook, MD, PhD, PLLC, professional.
Out of curiosity, are there any different arguments for the corporate defendant, corporate plaintiff versus the individual plaintiff?
They're not, the arguments are the same, Your Honor, but
Just asking whether you have any separate arguments you're making.
well, Dr. Brook is here, and he is the pro se plaintiff. The case didn't start out pro se. I wrote the complaint, 10 causes of action, 10 years ago. I'm 10 years older. We filed it, and here we are today. Also, this case was before this court in 2017, and you remanded it with 5 causes of action for discovery and trial. So,
Well, for discovery, not necessarily trial.
correct, and that's what we're here to argue about right now.
Okay, go ahead.
That's exactly right. I also do want to mention, as a matter of public record, the federal case, which is mentioned in and out in these papers, is currently on appeal in the D.C. Circuit, and that's to be heard. And this court had already said in 2017, don't take anything from the federal case. I wrote that complaint too. That's constitutional claims. That's not what's here. Now, it's very important here, Your Honor, that Justice Scarpula, when she was in the Supreme Court, she entered a spoliation order and restricted the defendants from referring to documents in a certain time period.
That seems like it's one of your weaker arguments that you're making, to be quite frank, the spoliation, because that spoliation had to do with a later time period than the subject of what most of these claims are about. So whether or not these claims are going to survive, it's not really going to be that affected by the spoliation or adverse inference one way or
I
another.
understand the time frame, Your Honor, but
Why not focus on what might be stronger arguments?
I will do that, but let me first tell you why I think this is a strong argument. Because one of the documents that was spoliated was Dr. Rubenstein's email directly to the administration saying, I was in the operating room and what you've been doing here in this investigation is fraudulent. That document was spoliated. But actually, and Judge Scarpula said at the time, the fact that that document was spoliated, but fortunately Dr. Brooke had a copy of it contemporaneously back in 2010, means that we had it, and who knows what else they spoliated. So my only point on spoliation, Your Honor, since we've proven it and it's been proven highly relevant, that's a reason that you cannot allow a party who has spoliated documents to get summary
You
judgment.
want to focus on the substantive claims why
Yes,
the
Your
court
Honor.
erred in dismissing them?
Yes, Your Honor, absolutely. So the main problem we have with the opinion below is the court came in, Justice Schechter, after Judge Scarpula had this for 6 years, had a huge record, 7,000 pages to review and understand. Her opinion doesn't cite any of the smoking guns that we paid attention to, wrote about, argued about, and they're in the brief. So I'm not going to take time, but there were 4 smoking guns, and the most serious of those, frankly, Your Honor,
By
is Mr.
smoking guns, you mean allegedly false statements?
No, smoking guns where there was the day of the meeting, right after the surgery, the next Monday, they wrote, investigation has begun. No notice to Dr. Brooke. It's in writing.
Counsel, I'm not sure why you're not focusing on the specific causes of action and why it was improper, why there's still viable claims, why immunity doesn't apply.
Yes,
why
Your
there
Honor.
were false statements. That seems to be the
Okay.
heart of your claim, and I haven't heard anything about it.
Okay, so the first one was the fraud claim. And on the fraud claim, the judge says, well, there could be no reliance because we have a statute, 2805L. That statute has been on the books for 23 years, has never been relied on in any litigation ever to say that physicians are supposed to know that no matter what their administrators tell them, something's going to be reported. In addition, that 2805L is restricted to only reporting certain types of situations.
Okay, your time's up now, so.
Yes, Your Honor.
You have time.
Do I have a rebuttal?
Yes,
2 minutes?
yes.
Thank you, Your Honor. I'll let Dr. Brooks for the pro se.
Regarding the spoliation, Your Honor is empowered to reconsider the spoliation sanction. Defendants didn't produce a single email from October 5th, 2009 through March 28th, 2012. And we know that Leonard Rosenberg was involved in this case from October 5th, 2009. There are emails going back and forth. They were worried they were going to get sued on October 5th, 2009. So respectfully, Your Honor, this court should reconsider this and extend the spoliation sanction back to October 5th, 2009.
That's
Now,
not
it
even
took me-
before us right now, but go ahead.
It took me 20 years of often 130-hour weeks during Harvard Medical School, residency, and fellowship to become a cardiothoracic surgeon. Defendants and their counsel destroyed that career and livelihood through a campaign that they have waged for the last 13 years. Mr. Rosenberg made repeated misleading statements in his March 24th, 2000 letter to the U.S. Department of Health and Human Services, including that Peconic placed me on suspension and that I purportedly knowingly resigned while under suspension and under investigation after purportedly having been informed of the investigation by Peconic's chief medical officer, Dr. Kubiak. The U.S. Department of Health and Human Services, June 25th, 2012 decision letter expressly references 4 times Mr. Rosenberg's statements that Peconic had placed me on suspension. Now, the 2001 MPT guidebook, rule at E20 says, and I quote, if the physician surrenders his or her clinical privileges during a summary suspension, that action must be reported to the MPTB. HHS relied on Rosenberg's false statements of suspension to decide the administrative review against me. Tortious interference with prospective economic advantage. In its 2017 decision, this court said that pursuant to 18 U.S.C. 1001A, federal filing of false statements is criminal. So why did Mr. Rosenberg lie with impunity to the federal agency, the U.S. Department of Health and Human Services? The reason is that Mr. Rosenberg knew he could get away if he had a $15 million insurance policy.
Sir, it's not counsel, so you can finish up on your rebuttal time, but your time's up for argument. Thank you.
Thank you, Your Honor. May it please the court. Our arguments are completely laid out in our brief. I'm not going to start repeating them here because I know your time is precious. I just wanted to point out several parts of the record that I think are important for your consideration. First, the trial court's finding that all alleged damages flow from the adverse action report is supported by a chart of 24 separate instances in which Dr. Brook made that exact claim throughout his various affidavits, memorandums of law, and
Counsel,
depositions.
let me focus on a few things. I know one of the big issues below was whether the immunity applies, because that would obviously knock out all the claims if it applied. And there were a number of alleged fraudulent statements. What about the statement that, that he would refrain from exercising surgical privileges pending hospital's investigation? Isn't that something that's in dispute? Isn't he taking a contrary view that he did decide not to exercise his cervical privileges, but he didn't know that the hospital was investigating when he decided to do that?
The question is whether or not the statement that he was under investigation is true. And it is clear from the record that it is true, and that specific issue was litigated by Dr. Brook in a federal court.
Let me just, I guess I didn't say that as clearly as I could have, because it also goes to the first alleged misrepresentation, which that he claims he was told that there was never any investigation. And that has not been determined one way or another whether or not he was told that he was under investigation, because he's saying that if he was told he was under investigation, he would not have resigned. Doesn't that create an issue of fact, which would...
Not in the least. It is utterly irrelevant to statutory immunity under 11137C, because that immunity applies as a matter of law unless the plaintiff can demonstrate that the statements in the adverse action report were false and were knowingly false when made. Dr. Brook has not been able to establish either one of those elements.
Isn't there an issue of fact as to the statement that he resigned while he knew he was under investigation? Isn't he arguing that's false?
It didn't say he resigned while he knew he was under investigation, and the databank guidelines make it very clear that a physician's knowledge of whether he's under investigation or not is irrelevant to the reporting requirement.
What about his claim that if he had known he was under investigation, he would not have resigned, he would have stayed on and gone through with the investigation instead of having it on the record that he resigned while he was under investigation, which he says he never would have done if he had known he was under investigation?
In addition to it being irrelevant to the statutory immunity, it raises the very important issue of an absolute lack of justifiable reliance on such a statement being made. The case law is clear that an individual cannot justifiably rely on a statement that an entity governed by state and federal law is going to ignore their legal obligations.
But I guess the question would be, in that adverse action report, there is a statement that indicates that on about Monday, October 5th, 2009, the physician agreed to refrain from exercising his privileges pending the hospital's investigation in this matter. And then by letter, he advised the hospital that he resigned effective October 16th.
Yes.
Why his opposition to that? Why doesn't that at least raise the issue of fact as to what these...
Because it's true. He did agree to cease exercising his privileges, so that particular part of the sentence is indisputably true. And it's already been determined that he was under investigation for the purposes of databank reporting requirements.
And what about the statements by, I'm going to call him Dr. K, because I'm not sure how to pronounce the last name, but didn't he make some representations to him saying that don't worry about it, there's no investigation, something in some substance?
No, that's Dr. Brooks' allegations. Dr. Kubiak never admitted making those statements.
But would that raise an issue of fact?
It still wouldn't raise an issue of fact. And let me point out, there's no dispute in the record that Dr. Brook, on that Monday, met with the hospital administrators to talk about the case, to talk about whether or not he would agree to voluntarily cease exercising his surgical privileges, which he did. He's alleged that he was initially told he was fired. It's common knowledge. All physicians know that if an improper body part is removed or if there's some issue, that a hospital has to make what's a NIPORTS report and a sentinel event report to the Joint Commission to say that he's just going to blindly accept the alleged statement, oh, there's no investigation. On the first day when people were talking about it, it totally lacks any credibility whatsoever. He knew what was going on.
Counsel, I'd like to follow up on that because certainly Dr. Brooke makes the allegations regarding October 5th and the 7th. And so how do you refute that, particularly since Dr. Kubiak indicated, I believe, he couldn't recall the conversation, I should say the contents of the conversation on the 5th, and really didn't even remember if there was a conversation on October 7th?
For the reasons stated in the decision below and multiple reasons in case law cited in our brief, that's irrelevant to the immunity and failure to make out the cause of action after full discovery.
But doesn't that raise issues of credibility? You have Dr. Brooks saying, yes, I was told on the 5th and 7th. And then Dr. Kubiak says, the 5th, I don't recall. The 7th, I don't have any memory. Isn't that a credibility issue?
No, because whether or not Dr. Kubiak made that statement to Dr. Brooke is not relevant to whether or not he's made out the claims with evidence sufficient to go to trial. I do want to point out in response to the unwarranted...
Time's up, unless you respond to that particular point.
I just want to respond to the personal attack against me and point out that in the record...
We're going to disregard any personal attack, Counsel.
Okay, thank you.
Thank you. You don't go next.
So first of all, I agree with Mr. Rosenberg that the statute 1137C says you get immunity, but only if everything in there is true and only if the hospital has no knowledge of falsity. But this record is full of things that are wrong in what they reported. As some of your honors have pointed out, they reported that he agreed not to exercise his privileges pending the investigation. He was told there was no investigation. They knew that, okay? The question, does the hospital know that its report is false? Dr. Rubenstein sent this spoliated email saying your whole investigation was full of false documents. It's in the record. It's in my brief. I quoted it. And then I do thank the court for recognizing I was cross-examining Dr. Kubiak on this critical discussion of October 5th and October 7th. Both times he said, I don't recall. Well, that means that Dr. Brooks' testimony about it, he recalls it very clearly, is going to be unrefuted at trial.
Sir, excuse me, with
Yes, sir.
respect to the claim for tortious interference with prospective economic advantage, marshal for me, if you will, the evidence that demonstrates a triable issue of fact on the causation element of that claim.
Yes, Your Honor. So the lower court incorrectly viewed it that you had to have an interference with a third party. But this court and the Second Circuit in Purchase versus Chirac said when you interfere with a physician's relationship with the regulatory agencies, that's tortious interference and there's damage from that. So that, and this court the lower court for some reason never mentions Purchases versus Chirac, a case I tried in 1992 in federal court. But for some reason, this court cited it. This court said two examples of tortious interference is a false statement to the data bank. Please read Mr. Rosenberg's March 24, 2011 letter saying all over the place that he was suspended, and then we find out, no, he was never suspended. And so the second thing that it said is, in this court's 2017 opinion, said that fraud on Dr. Brooke, telling him he wasn't being investigated, then allowing him to resign so that they could report him, that's a whole structure of tortious interference. And lastly, and last answer to your question, Your Honor, is there are very specific examples where, unrelated to immunity, there's no immunity for reporting to other hospitals. The Reston Hospital and the another hospital made inquiries, and were given false statements in response. That's in the record very clearly as well. The last
Do
thing
you have any other questions?
Oh, thank you.
Okay, thank you very much. No, you don't get extra time. I'm sorry, you don't get rebuttal.
Could I just say one more?
He has one.
Can I say
no,
one
no,
more
no,
sentence?
no, no. He has 1 minute.
Okay,
and
thank you.
that's it.
1 minute for Dr. Brook.
Okay, so first, Mr. Rosenberg's incorrect. A Databank Guidebook, page E34, says that to be reportable, an investigation, a surrender must happen to avoid an investigation. I want you to understand what happened on October 5th. He calls me in the morning, tells me I'm fired. He calls me back in the afternoon, says, I just spoke with Dr. Rubenstein, and I understand now it was just a complicated case with no malpractice, and it would be very unfair for us to take any action against you. I told him that, I almost certainly need to leave the hospital anyway to do a fellowship. But I said to him, before I resign, I need to know if I am or will be under investigation. And he told me no. And I asked him the same question again on October 7th. And again, he told me no. So that goes directly to fraud. So that's number one. Number two, under the bylaws, if you need to read the whole bylaws, section 5.9, don't read individual sections separately. Read it in continuity. It provides a very detailed procedure as to what's supposed to happen when someone gets investigated.
Thank you. We're familiar with the briefs and the record, and we'll review everything. Thank you very much. The next case is Lorenzo versus Great Performances.
Good afternoon, Your Honors. May it please the Court. My name is Douglas Herring here on behalf of the plaintiff appellant Hector Lorenzo. The respondent's liability under the Dram Shop Act in this case was established as a matter of law.
Counsel, why isn't there a question of fact based on the testimony of the groom where he stated that he never saw him intoxicated that night? Why wouldn't that create an issue of fact as to visible intoxication?
So the groom's testimony specifically was that he could not say, based on his interactions with John Yahara, what his level of intoxication or sobriety was. And specifically,
I think it was a little more direct than that. I think he did testify that he was not visibly, he did not see him visibly, he did not observe John acting intoxicated or behaving in an intoxicated manner.
yes, these are simply statements of lack of recollection.
No, he said he did not observe it. Why isn't him saying he did not observe it enough just by itself to create an issue of fact?
He repeatedly testified, both the bride and the groom repeatedly testified, that they barely recollected any interactions with their individual guests or moments within their wedding. It was an overwhelming blur of activity. And every single case relied on by the defendants.
No, let me just ask you this. This is the direct testimony. Okay, did you ever observe John Yahara acting or looking in a way that made you believe he was intoxicated? Answer, no. Toward the end of your wedding, did you notice John Yahara's clothing in any way to be disheveled? No. It's not, I don't recall, it's no. So doesn't that raise an issue of fact?
No, Your Honor, because he's not saying, I saw John Yahara, he did not appear this way. He's saying, I didn't see it. Every case relied upon by defendants involves affirmative testimony from a witness saying whether I served them or I was drinking with them, and they did not appear visibly intoxicated at that time. That's not what we have here from the groom.
Was there a video that might depict this, the interactions of the defendant rather, and could that be interpreted as anyways him not being visibly drunk? The better question, I guess, would that be something that should go to the jury for interpretation?
In combination with all of the testimonial evidence that John Yahara was appearing visibly intoxicated, in addition to the photographic evidence and the video evidence, As late as 11:30, shortly, less than half an hour before the assault occurred, video clearly depicting him sweating, flushed in the face, swaying on his feet, unsteady. And again, we just have to return to the total lack in this very lengthy, voluminous record, thousands of pages of testimony. There is not a single witness who affirmatively said that John Yahara was not
Counsel, putting aside the question of whether or not he was visibly intoxicated, the next issue is whether there's a causal connection between any intoxication and the assault. This record is very bereft of exactly why this assault took place, and we really can't tell, looking at the record, exactly why the assault took place. How can we then say, and there's also no testimony that he was acting violent before the assault, he was acting belligerent before the assault. How can we take from this record and say, as a matter of law, that there was a causal connection between any alleged intoxication and the assault that took place?
So that point was actually directly addressed by the Second Department case, Catania, where just like there was an unprovoked assault with...
In that case, which I'm familiar with, there was clearly undisputed evidence that the person who committed the assault was acting more and more aggressive and belligerent as the night went on. Where is that comparable testimony in this case that he was acting aggressive and belligerent before the assault took place?
So that begins shortly after 7:30 at the cocktail hour, where during the cocktail hour, the plaintiff and Chris Jones's testimony both describe his appearance as sloppy, loud, boisterous, overpowering.
Isn't a synonym for boisterous maybe jolly, merry, not necessarily aggressive?
Perhaps, and if that was the only adjective on the record, then we might be in a different factual scenario. But when you combine that with glassy eyes, slurred speech, unsteady on his feet.
Right before this incident, the plaintiff himself was going to have a drink, or shots, rather, with the defendant, right? Not that he was aggressive to him at that point or belligerent with him. They were actually going to spend some time together.
That is what the plaintiff appellant believed at the time, yes, although it was not the case, but yes.
Thank you. You have time on rebuttal.
Thank you, Your Honors.
Unless the bench has any more questions.
Good afternoon. My name is Alyssa Mendes. I represent the respondent, CPS 5. I think that your questions are right on point. I think that while plaintiff wants this to have met the burden of being, it can be decided on summary judgment as a matter of law, that there are a number of factual issues in this case.
What about the fact that there is no testimony from a bartender or one of the servers saying we observed him and we didn't notice any intoxication? What do we take from that absence in the record?
I can tell you that the bartenders were never deposed, so there's no testimony from them.
Was the deposition ever requested of the bartenders?
No, the plaintiff never requested depositions of the bartenders, and they never asked for it, so they were never taken. I can tell you, that it is in the papers and it is in the record that the manager who did testify did speak to one of the bartenders. He said that bartender said he was not visibly intoxicated. I know that that's hearsay, but it is not the only evidence being offered, so I think it can be considered in our opposition to the motion.
Did that manager put in an affidavit in opposition to the motion?
No, he did not. We have his deposition testimony, so I don't think the affidavit was going to add anything.
Oh, I see, okay.
More than the testimony.
Do we know how many people from the record approximately attended this reception?
I believe it was 200 or 250. It was a rather large wedding. So I do want to point out that in addition to the groom not having witnessed Mr. Yahara being visibly intoxicated, the bride also said that she did not believe at the time of the wedding that he was visibly intoxicated. She did not recall
So
that.
do you agree with counsel's interpretation of that testimony, that they didn't say that he wasn't intoxicated, they said they didn't see him?
No, they certainly saw him. Those were direct, the testimony you quoted was was their testimony. I mean, that's the testimony of the groom. Yes, I saw him, and when I saw him, he did not appear visibly intoxicated. In fact, the groom points out that there were 2 other people at the party that he did think were intoxicated, but that was not the assailant here. And again, this was completely unforeseen, this circumstance. There is no evidence that Mr. Yahara was getting belligerent during the night. I mean, the plaintiff does say that early on that he was loud and boisterous, which again can mean that he was happy and he was excited. It was his sister's wedding. I'm sure he was excited, and I'm sure he was happy to celebrate with her.
But we agree the causal connection required for the dram shop action is not the equivalent of a legal cause under the standard negligence element of causation. It's more of a more liberal causal
Correct.
connection, if you will, and so there has
Correct.
to be some connection between the visible intoxication and the injury?
Correct. That's right. That's the standard. But here, I think there's an issue of fact about what the actual cause was. And in fact, the testimony of the bride is that she believed that any drinking on the part of Mr. Yahara had nothing to do with this alleged assault. That in fact, it was something that the plaintiff said that caused Mr. Yahara to become upset, which led him, I guess, to a moment of insanity when he punched the plaintiff in the face. So I think that it's a question that the jury should decide. It's not.
What if that moment of quote-unquote insanity was fueled by the intoxication?
Well, I don't know that you can say that for sure. I think that that's the determination that a jury has to make. Was it the alcohol that made him do it, or was it the anger? Or maybe the jury says it's both, but I think it's definitely a question for the jury, and it's not a question for the court. I think the court made the proper ruling here that there were issues of fact, and that summary judgment, the plaintiff was not entitled to it. So I think I'm good, as I'm almost out of time, unless there's any more
Any
questions.
further questions? Thank you very much.
Thank you.
Thank you, Your Honors. First, the groom's testimony at page 3075 of the record. Is it fair to say you don't know the level of intoxication or sobriety of John Yahara by the end of the evening? Answer, no, I don't. I didn't know or can say what his level of sobriety would have been. He repeatedly testified he was not paying attention to his guest's alcohol intake, whereas minutes after the assault, you have Security Officer Jonathan Gross saying that the men in the hallway, including John Yahara, appeared to have had a lot of alcohol.
But counsel, if I'm not mistaken, I believe it's Respondent's Appendix 2279 and 80. There was a particular question if he observed that he was intoxicated. He said no. So how do we deal with that? He said no.
So that, again, goes back to the point which he stressed repeatedly in his deposition, that he was not paying attention to alcohol intake and could not say how much nearly any of his guests had, other than the two that he did specify.
But why isn't that then, issues that go before the jury? Let the jury hear it and judge the credibility. How is this a matter of law, a decision that can be made as a matter of law?
A decision should be made as a matter of law here, Your Honor, because in the thousands of pages of evidence in this record, there is no affirmative evidence that he wasn't intoxicated, simply lack of recollections or gaps in the evidence, but no affirmative evidence whatsoever. Thank you very much.
Thank you very much. The next case is Bracco versus Eastern Metal Recycling. Go ahead.
May I proceed?
Yes.
Good afternoon, Your Honors. May it please the Court. My name is Michael Romano, attorney for plaintiffs and appellants Giacomino and Francine Bracco. The defendants, the lower court had erred in dismissing our case on the basis of absence of long-arm jurisdiction. I think the facts are clear that Eastern Metal Recycling's contacts with New York State were both intentional and continuous.
Sir, I'm sorry, are you conceding that there was no general jurisdiction over Eastern Metal Recycling?
No, Your Honor, if I'm mistaken. General jurisdiction was in fact over Eastern Metal, based upon the fact that in their website, about many other facts, but in the website alone at the time the incident took place, they specifically injected the same address, Calcutta Road in Newark, the entity name of Eastern Metal, Inc., and essentially, which was, we alleged, was an affiliate of Eastern Metal Recycling, LLC. In addition to that,
Counsel, even if it was an affiliate, what difference does it make? Don't you have to look under the Supreme Court precedent at where the particular corporation being sued either is incorporated or has their principal place of business, and that they've instructed us if they don't have their principal place of business or incorporated in that state, then there's no jurisdiction.
They have instructed that, yet, however...
So why do we care about an affiliate then?
Well, that's their argument is a different entity. Our argument
Let's say you're right, that it's an affiliate and not a different entity. Let's say we even accept that as true. How does that change what the Supreme Court has instructed as a current state of law about jurisdiction over a corporation?
Well, Your Honor, with regard to that, the case that came after Daimler, which we mentioned is Reich versus Lopez, says that in this situation, Daimler does not prevent the exercise of...
In which situation? When affiliate?
Well, affiliate was a word that just to make it's may or may not be, and that's a question for the jury, because defendants are saying that it's a different entity. They're also saying that Eastern Metal Recycling, the named party, has never hired and have never bought or leased any trucks. These are all questions of fact that...
No, but I mean, you can't, you're the party who has the ultimate burden of proof. You can't just throw it up in the air and hope that something sticks. What do you have? What kind of evidence do you have to substantiate what you're saying?
I have the sworn testimony of a non-party witness, Michael Mianardis, which says that Eastern Metal had sent trucks back and forth to New York to bring...
But that is not, we're talking, that's a different section of jurisdiction, right? We're talking about general jurisdiction. You're not conceding general jurisdiction. So I'm asking you, what facts do you have that you allege, because you have to do your own investigation. Again,
Sure.
You can't just throw it up against the wall, to say that this company is subject to general jurisdiction under Daimler.
So in our investigation, we found that the facts were that Eastern Metal has a New York State scrap collector license and scrap processor license, or at least they did from 2011 through 2017. Also, they had an office in Poughkeepsie, Selkirk, as well as Green Island, which appeared to have been registered as a health facility under New York State DMV vehicle safety.
And you're saying this company had that, all those things?
That's what our investigation had showed.
Okay, and because I thought you were saying, what do you mean that this company had your investigation? How did your investigation show it?
Well, it had showed that so on the website, it's Eastern Metal Recycling, that's it. Okay, they're trying to say Eastern Metal Recycling Incorporated, Eastern Metal Recycling LLC.
No, I mean, they are different things, right?
They are different.
Right?
However, that website, I think, purposely projects them into New York State by listing all these addresses.
So again, that's a different thing from general jurisdiction. Let's move on then, right, to 302. Let's do that, because I don't think you've said anything that about 301 that's different than what we've heard. What are you saying about 302?
302, there was sworn testimony to say that Eastern Metal had delivered trucks back and forth into New York. Additionally, the testimony of...
Delivered its own trucks?
That's what the testimony of Mr. Mianardis had said, that for deliveries to the, I think it was Edison...
And how is that connected to the accident?
Well, that may not be so directly. However...
Okay, but you need that, right?
Yeah, so the conversations between Mr. Mianardis and Frank Anseris of Eastern Metal are certainly connected, because in those conversations, in the testimony of Mr. Mianardis, it does in fact say they had many conversations about concerns about the safety of the Calcutta Road site where my client got hurt. There was back and forth communications about the issues that the truck drivers are having. Ultimately, those safety issues led to my client being injured. So that is in fact connected, and that is in fact what's brought up under.
Thank you. You'll have time on rebuttal.
Okay, thank you.
May it please court, my name is Richard Benson. I represent Eastern Metal Recycling Terminal, LLC. In retrospect, looking at the briefs last night, I decided that there was really a big mistake that was made throughout, because all we did was represent EMR. But EMR is a separate company. It's a New York Corp company. It's not the party that plaintiff sued in this
Counsel,
case.
tell us why you think there isn't jurisdiction under CPLR 302 as opposed to
This is an
301.
accident that happened in New Jersey. It happened at a particular location in New Jersey with regard to the site of the accident. But there's no connection with anything in New York that pertains to that location. And
Is
there must be
your
some
company is
connection.
a New Jersey company, correct?
It's a Delaware corporation
right.
with a principal place of business in New
Sorry.
Jersey.
Right. And the accident happened in New Jersey.
Correct.
And, okay, so the conversations about safety between, I think, which the plaintiff is alleging, those were about the New Jersey property, correct?
That's the way.
Assuming they happened.
Assuming that they happened, I assume so, although there was testimony also that they sent materials down to Camden as well as to Newark. But, so I don't know exactly on that, Judge. I can't tell you specifically.
Does
I
an
would-
issue, I'm sorry, go ahead and finish your answer, sorry.
I'm fine, Judge.
Is there an issue of fact as to the relationship, if any, as to your client and these other entities that your friend identified in his investigation that bear a similar name?
No, Judge, he sued a corporate, an entity, a limited liability company. That's who he sued. He didn't sue a group of things. He didn't sue a bunch of other companies. I can only represent and defend the company that he sued. At this point, to open it up into, well, I meant to sue some other company, well, that's not what this case is about, Judge. He has to prove that there's jurisdiction over my client in this case, not some other entity that has a similar name, related or not. Thank you, Judge.
Thank you very much.
Good afternoon, Your Honors. My name is Maxine Nicholas. I'm an attorney with Gordon Reese on behalf of the respondents, Port Authority of New York, New Jersey, and Port of Newark Terminal. With me is James Messenger of Gordon Reese. He's been admitted pro hoc vice, and I respectfully request that he be permitted to participate in the appeal.
Permission is granted.
Good afternoon. I'll keep my argument short because there was no mention of my client on the
We're going to ask him
argument.
about that in rebuttal, so go ahead.
Yes, thank you. I do represent Port Authority of New York and New Jersey and the Port of Newark Terminal. I call them Port Authority here. I just really like to make, I think, 3 points. One is it's an appeal from a summary judgment order finding that Port Authority was not liable because it was an out-of-possession landlord. And the order of the decision, I'm just going to quote 2 sentences. There is no allegation of a statutory violation or structural defect. A review of the permit shows that Port Authority had no obligation to make repairs or maintain the property and no liability with respect to any vehicles on the property. Deposition testimony established that EMR had exclusive responsibility and control of the property. Second point I'd like to make is just to briefly summarize the law and apply the facts, the record. The law in New York is abundantly clear. An out-of-possession landlord is not liable if it had no contractual obligation to make repairs and didn't retain control of the property. What's the evidence here? The permit's in the record. There are numerous provisions in the permit where Port Authority states, in the permit states, it has no obligation to maintain the premises or make repairs. And among others, they're in the brief, are paragraphs 12 of the permit and endorsement 6.3. In fact, the permit...
What about the alleged OSHA violations?
The OSHA violations, two things. An out-of-possession landlord can be liable with the right to reenter if there is a specific statutory violation and a specific significant structural defect or design defect. Number one, with respect to the OSHA violation, Port Authority is not the employer, of the plaintiff. It can't be liable for OSHA. We cited, I think, at page 37 of our brief, the Brager case, which I believe directly addresses this issue. So there's no connection.
And so you're saying because the OSHA violations aren't connected to a structural defect that might sort of allow the plaintiff in to an out-of-possession landlord claim?
That might be true, but what I was trying, the point I was trying to make is that the statutory violation is not attributable to Port Authority because it's not the employer. And the Brager case cited at page 37 of our brief addresses that. Independent of that, they would also have to show a significant structural defect or design defect, and they haven't done that. That was clear in the court's summary judgment decision. What they're alleging here is water on the floor, inadequate lighting. Courts in New York, in fact, recently, there was a case, I think 2 or 3 weeks ago from one of the panel members, but courts in New York have held things like water on the floor are not significant structural defects or design defects, and it would be the other areas of their inquiry. So by way of really conclusion, there is no contractual obligation to maintain and repair. The evidence establishes that, and it's a statement of fact not disputed by either of the other two parties, Eastern Metal had exclusive responsibility and control over the property, including the area where the accident occurred. And with respect to that we do have the right to reenter in the event of an emergency, but with respect to the exception you're referring to, respectfully, there is no statutory violation attributable to Port Authority, and moreover, there's nothing, not even an allegation, but certainly nothing in the record. They haven't met their summary judgment burden of establishing a significant structural defect or design defect. If the court has no further questions, if the court has any questions, I'm here, but that concludes my argument.
Thank you very much.
Thank you.
To respond to Port Authority's responses, to minimize this to water on the floor, the ground collapsed, or at least we allege, the ground collapsed underneath the client's truck that he was driving. That caused the truck to roll over and cause injury. Additionally, most importantly, in the permit, the Port Authority was allowed to promulgate laws specifically regarding safety. They could take their own unilateral actions related to safety and protection of property.
Let's just go back. So what was the significant structural or design defect? What was it?
The ground itself, the whole yard itself, was left in disrepair. There was lack of light.
Did you plead that in your bill of particulars?
The whole basis of our case is our allegation, and we had an expert review the site, that the ground collapsed underneath my client's truck, and that caused it to roll over while he was dumping. That sounds significantly structural to me.
Thank you very much. Any other questions? Thank you.
Thank you, Your Honor.
The next case is People versus Castellanos, Perez Castellanos.
May it please the court, my name is Abigail Everett for Appellate Mr. Perez Castellanos. There are two significant evidentiary issues in this case. I'd like to start with the extensive evidence regarding numerous out-of-court conversations between the complainants and their family members. Normally, all these prior consistent statements wouldn't be permitted. When you have a case involving a child sex victim who's delayed many years of reporting, the courts do permit a certain amount of evidence regarding disclosure to put the circumstances of disclosure into context for the people and to provide background. And the judge ruled that it could come in to complete the narrative and to sort of show how the investigation began. Our point is, when you look at the extensive amount of testimony that came in, not just from the 4 complainants, but from their mothers and their brothers, and talking about conversations that took place between various family members not involving the complainant.
Did the court offer any limiting instructions for the jury?
I think that the jury was told that what the purpose of the testimony was. My point is that because it was so prejudicial, there was testimony that one family member called another family member to say that a complainant had tried to commit suicide because of what Appellate purportedly did to her. And you've got not just the complainant, Jalen, saying, I told my mother, and the mother testifying that, yes, we had this conversation, but then you have Jalen saying, and I told my brother on one occasion, and I told my brother on another occasion, and you have the brother come in and say, yes, she told me.
Did the defendant place the witnesses' testimony or their position? He's placing a credibility factor on that, right? So why wouldn't this, with the limited instruction, be allowed?
I think that the court needs to provide some guidance for the trial judges, that the DA argued in this case below that the courts allow expansive evidence. I think that was the word that was used. And that's really the stance that the judge took, an expansive letting in of all this evidence.
Counsel, under the circumstances of this case, where there was a number of years before the disclosure took place and it unfolded allegedly victim by victim by victim, in addition to the fact that there was a consistent position that they were all lying, wasn't this a case where it should be more expansive than in other cases where these circumstances were not present?
I think in every case, the reason it's coming in is because there's you need to show the circumstances to prevent an argument that the person is lying. It's not a prompt outcry, but it's an explanation for delayed disclosure.
But isn't there even more in this case where there's 4 separate victims, all from the same family, and a significant delay in terms of their disclosures and the timing of their various disclosures about what occurred? Isn't this, again, a case where there's more reason than the typical case where there might be one victim or not so great a time where it'd be necessary to allow in more to put everything into context?
You're going to have more just by virtue of the fact that you've got 4 complainants testifying, and if you had their mothers also talking about the circumstances of that initial disclosure, that would be a fair amount. But when you look at the transcript in this case, it far exceeded what you might expect even in a case with 4 complainants in the same family. I would also like to turn, unless there are other questions on this, to the Molyneux point. You've got a fair amount of testimony coming in also for uncharged periods of crime. The judge felt that you needed to show that there was some context, but again, there was no opening of the door where the defense...
So isn't this, again, an unusual case in terms of the factual circumstances? Because if you didn't allow in the evidence of the uncharged acts based on the statutory limitations on what claims could be charged, it really wouldn't make sense. The story of how the sexual abuse allegedly went on for years and years, et cetera, none of that would make sense without letting in pretty extensive testimony about uncharged acts.
Well, I don't agree, because I think the judge could have just charged the jury that this is what happened before you. This is not a case where the defendant suggested that it started arbitrarily. I see the white light is on. Let me turn to the sentence point.
Well, I just want to stay, I want to stay on the Molyneux just for a second. Can you tell us what, if any, prejudice took place? Because wasn't all of the counts relating to Freddie, those were, he was acquitted, right? And then
he was acquitted.
The other child as well, correct?
He was acquitted of 2 of the 4, but one of the main incidents that happened before the period of charged crime was the trip to Florida, where there was testimony basically of a nature of a sexual assault, oral sexual contact. There was a very extreme event described involving Jalen, and Ashley was there as well, and they were very young, and the defendant was very young. This was in an uncharged crime that would ask the court to consider how prejudicial this would be. This is not a situation where he was acquitted of all the acts concerning that. Now, on the sentence point, the minimum for all these would be 10 to life concurrent. The judge imposes the maximum sentence, 25 to life consecutive to 25. This is the person.
Did the defendant ever admit that he was, that this had happened?
No, he didn't. He maintained his innocence, as is common at a trial.
Absolutely, but so I mean, as this is right, correct, and absolutely true, but then those 4 people had to testify through a very long and painful trial, right?
Yes, Your Honor,
And the
although he
trial
was
judge
acquitted on
was-
2 of the 4.
And the trial judge is in the situation, generally, in the best situation, to figure out in that circumstance what the best sentence is under those circumstances.
I would ask the court to consider how young Mr. Perez Castellano was during these crimes, and the very unusual circumstance that in the 7 to 10 years that elapsed between his youthful commission of these serious crimes, he went on, he got a college degree, he worked steadily, he supported his fiancée, his child, and his stepdaughter. There were no other involvement with the criminal justice system. He also, he had an enormous number of letters from the community involving
Thank you.
employers.
You also have a minute on rebuttal to talk
Thank you, Your
about the sentence.
Good afternoon. May it please the court. Rachel Bond for the people. Briefly as to the Molyneux arguments here, the Molyneux evidence here was included to establish not only critical background for the jury to be able to consider the charged crimes fairly, it also placed the victims and the defendant's behavior in the testimony about the charged crimes in a more believable context. It explained the relationship between defendant and the victims over time. It explains the delays in disclosure, and it was also inextricably interwoven.
Counsel, can you address the sentence?
The sentence?
Yeah.
Yes. As to the sentence, defendant
This
claims...
is a first-time offender. He's pretty young, and he gets 2 terms of 25 to life, right? The maximum sentence in both. Can you address why that's not excessive?
Yes, Your Honor. So I think the defendant's crimes in this case, as is apparent from the record, were incredibly heinous. They're on, as the trial judge said, they're on the high end of the spectrum, even though all crimes of this nature are heinous. This is especially so. And there were 2 separate victims who were victimized at separate times, and it was over the course of numerous years. The victims explained in their impact statements that they had experienced ongoing feelings of fear, worthlessness, powerlessness, depression. And so I think in light of all of those things, and again, the fact that the defendant has not taken any responsibility or even expressed any sort of sympathy, he's continued to claim that all of the victims are lying, and as was brought out during jury deliberations, potentially even tried to bully them into recanting. So I think in light of all of those factors, the sentence of the maximum here run consecutively was warranted. And then briefly as to the hearsay point as well, the disclosure testimony was relevant to explain how the abuse came to light, the investigative process. It was also admissible to directly rebut the defense arguments at trial. He opened on the idea that all of the people's witnesses were lying and had been actually abused by one of the other victims. And additionally, the court did give numerous instructions as to how this kind of evidence was supposed to be used. So if there are no further questions, we would ask that you affirm.
Thank you very much.
I just point out when respondent refers to all of the victims that he wasn't convicted of all of the complainants. There were 2, just to put that, to make that clear. On the sentence point, this is a very unusual case where you have somebody who was quite young when these crimes were committed. It's true that they're serious crimes, but there's an enormous difference between the minimum sentence of 10 to life concurrent and a maximum of 25 and 25 to life. that's 50 to life versus 10 to life. And I would think that it's unusual to have a defendant, a first offender, even in a serious case, who has done so well after the time period when he was alleged to have committed, or convicted, I should say, of committing the crimes. The other thing to keep in mind on this case is that, I'm sorry, I just drew a blank, I'm sorry. And this is an enormous spread, and I would ask the court, please, to use its interest of justice, as it did in other cases cited in our reply brief, to modify the sentence. Thank you.
Thank you very much. The next case is Prime Property versus Imperio Transport.
Good afternoon, Your Honors. David Kupfer, the Kennedy's law firm for the Appellant Prime Property and Casualty Insurance Company. May it please the court. Your Honor, the trial judge found as a matter of law that Prime unreasonably delayed in denying coverage by commencing a declaratory judgment action. I'd submit to the court that not only was that decision improvidently made, it's only possible to decide as a matter of law in extreme cases that an insurance company unreasonably delayed, and the trial court made no findings.
Counsel, why don't we focus on the merits of the denial? Because obviously that argument very much hinges on whether or not there actually was coverage or not under the policy. Why should there be coverage under the policy? Isn't there an argument that there's an ambiguity between the various provisions of the policy, which if there is, would be ruled in favor of the insured and therefore provide coverage? Well, so I'd like you to address that.
Yes,
how you harmonize Section 2 of the policy with the schedule endorsement and the declarations page.
Your Honor, Prime provides in its policies that there will only be coverage for scheduled drivers and scheduled vehicles. That informs the risk that it chooses to underwrite.
But isn't that directly contradictory to the language in Section 2 of the policy, which is much broader and says that all permissive drivers of the covered vehicle, which this is, will be allowed? So if you just look at Section 2 alone, doesn't that clearly provide coverage in this case?
Your Honor, I don't deny that there's coverage under the policy for permissive users.
So how does the scheduled driver's endorsement clearly state that it is trumping the coverage which is clearly provided in Section 2 of the policy?
Because Prime has its policyholders sign a personal guarantee that provides that if Prime is obligated to afford coverage to a permissive user who is not scheduled under the policyholder and the principal of the policyholder agrees to indemnify and reimburse Prime for any money it might have to pay on account of the judgment. That's how it's able to afford coverage to permissive users. Prime recognizes that as a matter of law, in certain states, it is obligated to afford insurance to people using a covered vehicle.
So we're going to look at the policy itself because there's no extrinsic evidence. Where in the policy itself does it make clear that a permissive driver, which would have coverage under Section 2, is not given coverage because they are not listed as a scheduled driver? Where does it unambiguously say that in the four corners of the policy?
Well, the endorsement to the policy that says that only scheduled drivers are covered informs the policyholder
So
of
what's the exact language that you're relying on in the scheduled driver's endorsement to support your claim that it clearly overrides Section 2? What precise language are you relying on?
Your Honor, I'm not making the argument that it clearly overrides Section 2.
Well, if it doesn't, why is it? If it doesn't override Section 2, then why aren't we left with an ambiguity as to which section controls?
Because the relief we seek is the trial court erred in dismissing our entire declaratory judgment complaint. There was a count of the complaint that sought judgment against Imperio, the policyholder, and the principal of Imperio to reimburse Prime if it had to pay money on account of an unscheduled driver. The trial court dismissed that claim. We should still have the right to pursue our judgment against Imperio and against the principal of Imperio if we are required to pay a judgment against
I'm not
Imperio.
understanding. Are you claiming that you have a right against Imperio that's separate and apart from the policy that we're examining in this case?
That's
That
correct,
there's a separate agreement?
That's correct, Your Honor. There is a personal guarantee. It's referenced in our brief. There's a personal guarantee that Prime requires its policyholders to enter into that says that if Prime has to pay a judgment or settle a case on account of an unscheduled driver not covered under the policy, then the policyholder has to reimburse Prime for that.
And is that part of what you argued below and to the First Department in terms of arguing for, was that part of your argument on this appeal? That it was improper to, let me just finish, to dismiss this because there's a separate indemnification and guarantee separate and apart from the policy?
That was an argument that we made in the trial court below, Your Honor.
Was it part of the appeal? I mean, we can only decide what's before us in this appeal. So I need to know whether, because I don't recall seeing that exactly, that that's the argument you're making on this appeal, that the court below erred in not separately addressing this indemnification guarantee separate and apart from the terms of the policy?
The trial court's decision below was merely that Prime had failed to comply with Section 3420.
So how can we be addressing that argument if you didn't make that argument to us?
Well, because we believe that the court should not have entered judgment against Prime solely based on Section 3420 as a
Why
matter
didn't you
of law.
make, if that is you think is your winning argument, why wasn't that part of the argument on appeal that the court erred in dismissing the declaratory judgment action because it wasn't, it didn't consider this whole indemnification separate guarantee argument?
I understand Your Honor's point.
Okay, thank you very much. I'm just
Thank
trying to get clarification.
Thank you, Your Honor.
Thank you.
Good afternoon, if it pleases the court. John Raytown, no problem. For Respondent Progressive, I do concur with most of the, go ahead.
Let me just ask you, do you agree that the policy is ambiguous?
I would say that Section 2 makes it pretty clear that there is coverage, and the one section in the deck page that they refer to suggest there isn't coverage has a sentence that immediately precedes that says all operations and activities contained within the policy remain in effect, which means Section 2, which states that any driver of an insured vehicle, and this is clearly insured, driving with permission is insured. So I don't know how else to read it.
What effect should we give to the scheduled driver's endorsement and declaration, which clearly state that there's only coverage for scheduled drivers, which this Perez clearly was not?
Right, well, the endorsement doesn't actually address coverage at all. It's the one line in the deck page that says that if you're not on the list, then you wouldn't be insured. But the statement, the sentence immediately preceding that says that all of the operations and activities defined in the policy remain in effect.
Well, tell me why you're taking the position that the endorsement doesn't address coverage.
Well, it doesn't say coverage. So what I'm arguing, what I'm saying is that the deck page refers back to it. I recognize what's in the deck page. I'm not denying what's in the policy at all. What I'm saying, though, is that the endorsement itself, by itself, does not say that there's coverage or not coverage. Whether you read it that way will depend on what's in the deck page.
Coverage.
You'd have to read it with the deck page to say that there would be no coverage, and you'd have to read only that one sentence in the deck page to read it, not the sentence to precede it. Otherwise, there would still be coverage.
Counsel, I'm sorry, go ahead.
The deck page summarizes the policy, and then there's the endorsement page, because I'm looking over the scheduled drivers endorsement, and it says no new drivers or operators will be added, named driver or operated listing, and this endorsement changes the terms and conditions of the policy issued. Are you saying that that is not specific enough to modify the information about the permissive in Section 2?
Not compared to, I mean, Section 2 specifically says, in addition to the deck page, which is being used to connect to the endorsement, it says all operations and activities within the policy remain in play. The operation activity of operating an insured vehicle with permission is in Section 2 of the policy. So I don't see how it could be read in any different way. And if there's a reasonable interpretation that would allow for coverage, then there would be coverage. I don't know whether I addressed that directly or not. I mean, I tried to.
So you are for
Progressive.
right?
Correct,
And
yes.
and do you agree with counsel that the trial court below dismissed the case from between the cause of action, Prime against Imperio, because of late notice and?
No, I'm not really sure what he was referring to there. I know that there was
Is there a cause of I don't recall there being a cause of action saying.
is listed
Is it an
in
indemnification claim?
that was news to me, just like the argument that there was no permissive use was news to me from a few weeks ago. So no, I've never heard of an insurance policy where you sign up to get insurance and then promise to pay the claim that you just got insurance for. That's what it sounded like to me. I'm not familiar with that.
Okay, thank you.
Anything else? Great, thank you very much.
Thank you very much.
May it please the court, Eric Turkowitz, for respondents Wanda Stewart and Wallace Hunter. These are two of the passengers in the car that was rear-ended. I'm only going to be addressing one point, and that is the employee and permissive use status with respect to the driver. It was raised for the very first time in this case in a reply brief here. It was not raised in the court below. In the initial brief that was filed by Prime, in the opening paragraph, in the statement of facts, it specifically calls Mr. Perez an employee. And so there was no dispute about it. In addition, in the case that I'm handling directly against Imperio, Imperio defaulted. Everything in the complaint is deemed to be admitted, every fact. If this issue had been raised in the court below, then that complaint would have been one of the exhibits I would have put in, saying, look, right here it says he's driving with permission and consent, and he's an employee. It's not in the record, but of course it's a public record that the court can take judicial notice of if it wishes. But these issues were already decided in the court below. And in the court below, I'm sorry, in the other case of Stewart and Hunter against Imperio. And it was improper, and to bring that up, the issue of employee status and consent in a reply brief, changing course in the middle of the briefing process when there was no substantiation below.
Thank you.
Good afternoon, Your Honor. May it please the court. My name is Alex Ross with the firm of Ross, Katz, and Pachananda. We represent Imperio Transport Corp. and Oscar Rodriguez. I have no inclination to take up any more of the court's time.
I just want to ask you, did you understand that there was a claim from Prime against you for, I guess, some kind of indemnification because Imperio let its employee drive the truck?
No, I did not, Your Honor. That hasn't been raised. I haven't seen the personal guarantee that Mr. Kennedy referred to. So no, Your Honor.
Okay.
Thank you.
Thank you. I concur with my learned colleagues, and unless there's any further questions, I cede my time.
Thank you very much.
Your Honors, I just wish to make two quick points in reply. The first is that the trial court did not find as a matter of law that the policy is ambiguous. The trial court found as a matter of law that Prime should be stopped from denying coverage because it didn't comply with Section 3420, and that decision is founded upon a misunderstanding of the facts of the case. The court found if it is determined that he, the driver, was in fact one of Imperio's employees, says, but for that endorsement, Prime would have been insured under the policy if it is determined that he, the driver, was one of Imperio's employees. Plaintiff was required to serve a timely disclaimer as required by Section 3420. And that was the rub. When the claim came in, it wasn't He wasn't a scheduled driver, and Prime didn't know whether this was one of Imperio's employees. That's the inherent inconsistency in the court's decision. But I understand the court's questions about whether the policy is ambiguous, but that was not the basis for the trial court's decision. The trial court wants
That
to...
was your argument to us. Your argument to us was that the disclaimer insurance law does not apply because there was no coverage in the first instance. So you brought up the argument by making that argument.
Well, my only point, Your Honor, is there is not a record below that the policy is ambiguous as a matter of law.
Right, but you clearly raised it as part of the appeal by making that argument to us.
We don't believe that the policy is ambiguous, Your Honor.
Okay, thank you very much.
So the other quick...
Thank you.
Thank you, Your Honor.
The next case is Shevlin versus Wonderworks.
Good afternoon, Your Honors. Stephen Gordon of Sigaz and Associates for Appellate Wonderworks Construction Company. We are here appealing 3 decisions by the lower court, including the decision denying our client's motion to dismiss the complaint for failure to plead a cause of action, the second, the decision after trial, and the third being a decision denying our motion in limine to introduce the deposition testimony of an unavailable witness. The trial court denied our client our motion to dismiss on the grounds that it was untimely, and then mentioned that even if it wasn't untimely, that the plaintiff had properly pled the elements for a cause of action under Labor Law 740. We vehemently reject that our motion to dismiss was untimely at CPLR 3211E, as well as...
So even if it timely, untimely, why did that motion to dismiss have any merit to it?
It had merit to it because the plaintiff failed to plead that our client actually violated a law, which is based on the wording of the statute, Labor Law 740.
There's an allegation in the complaint that he was fired because he refused to comply with defendant's instruction that he keep gates open in violation of the building code. Doesn't that clearly imply and give reasonable inference that the building code applied to defendants with respect to the gates at the project site, and that it was defendant's practice or procedure not to comply with the statute, based on that allegation?
Respectfully, Your Honor, I disagree. I don't believe that allegation leads to any conclusion that our client had violated the law. There's no...
But this is a 3211 motion, not a motion for summary judgment, right?
Yes.
So we're looking at it differently. We're reading it broadly, every favorable inference to the plaintiff. Maybe your arguments would be better on a summary judgment motion, but in terms of the pleading for Labor Law 740, why isn't that there?
In terms of the pleading, because, so to plead a claim under Labor Law 740, you need to plead that the employer actually violated a law, rule, or regulation, and that the law, rule, or regulation caused a serious and substantial danger to the public. Now, there's no allegation that our client actually engaged in any unlawful practices. The only allegations are that he was instructed to supposedly violate this law, which there's also there's no facts asserted as to how this law even applies.
But we're a pleading notice state, right? We're a notice pleading state, right?
Yes.
So you sort of, and then you go in and you take discovery, which is pretty standard, and the complaint has enough in it to give you notice that the plaintiff is saying that it was a violation of the building code to keep that gate open. You instructed him to violate the building code, and when he refused to do it, you fired him. That's basically what the complaint says. Now, is it the most detailed complaint? Absolutely not. But again, and as my colleague mentioned, this is a 30-11 motion. We're a notice pleading state, and you're saying you had no idea what the claim was about?
No, I'm not saying I have no idea what the claim
So
is
then
about.
you do discuss, so why do you get dismissal?
We get dismissal because he doesn't actually plead the elements.
What element do you think he didn't plead?
He didn't plead that our client actually violated the law.
You don't think instructing him to violate the building code was sufficient to plead that?
Instructing someone, instructing someone is not my client actually violating the law. They have to plead that my client actually violated the law.
If you instruct your employee to violate the law, your company can't violate the law. It's done by employees. The company itself is inanimate. So if you say, my client was instructed as an employee of the company to violate the law, you don't think that's sufficient?
No, there needs to actually be a violation first. That's what this court said in Remba v. Federal Employer and Guidance Services. It says labor law 742A, B, and C are not separate and distinct, but rather part of a statutory scheme to protect employees who blow the whistle on employers engaging in unlawful activities which create and present a substantial and specific danger to the public health or safety.
Thank you. You have time on rebuttal.
If I may I have 2 minutes for rebuttal? There's 3 different decisions here, and I only got to get through one.
Time in the middle.
Oh,
Sorry.
okay. No problem.
If we have more questions, we'll keep asking questions. The time's only for you, not for us, so.
May it please the court, Michael O'Neill for the respondent. I think that the court's questions are...
Counsel, do you agree with your adversary's assertion that there has to be a pre-existing violation?
No, and it's absurd. There are 3 sections to 740 that impose liability, and we're under Section C, which says if you refuse to violate the law and get fired for it, you have a cause of action. Now, it seems to me very plain, if you refuse to do it, you haven't done it, you haven't violated the law. Whether the employer finds somebody else to violate the law is irrelevant to the client's claim. I mean, that's, to me, so plain, I don't understand the argument. Now, he raises the Remba case. Well, the issue in the Remba case was whether the language, and I'll quote it, quote, which violation creates and presents a substantial and specific danger to the public health or safety, is grafted into Section C, which is fine, because all that means is that if he refuses to do something, which is the same sort of thing that's discussed in A and B, then and is fired for it, then there's liability. It has to do with the nature of the violation that he's refusing to do, not that it's actually been a violation. And then there's also the Villerin case from this panel, from this court, where an employee of, I believe it was like a child care center or something of that nature, refused to, was instructed not to file a report, which would have been a violation, and she filed the report anyways and was fired.
Let me ask you, how do you respond to your adversary's argument that you didn't adequately support your claim for lost wages?
Well, I disagree with that. I mean, this is a claim of, essentially, we'll call it wrongful termination. So the measure of damages would be the amount of money that he would have earned minus what he did earn. And so we presented what he would have earned, which was...
How did you present it, I guess? That's the question. No tax returns, no documents.
Right. Well, we did it with W-2 forms. So the W-2 forms that the defendant issued will establish what he would have earned. I don't know, they don't dispute that. In fact, they didn't dispute it at all during trial. And he testified to what he did earn, and he submitted W-2 forms for what he did earn. Now, tax returns are not limited to earned income. It's only earned income which mitigates. So if he had had a lottery winning or an inheritance, had all sorts of investment income, irrelevant. They didn't ask for the tax returns in discovery. They could have done that. So I don't understand the objection there. To me, it's a very simple case, right? He was told, leave the gates open. He refused. They fired him. He sent an email saying, you fired me because I wouldn't leave the gates open. They didn't dispute that. I don't understand. It's very simple. We had a trial. The lower court, I think, issued a very comprehensive decision. Was the finder of fact, and that's how the court found it. You have no more?
Thank you.
Thank you very much.
I'd like to make 2 points. So I do not believe this was a very simple case. If you read the record, there is no evidence in which to believe anything that the respondent testified to. He lied continuously throughout his entire testimony. He was impeached for lying at his deposition regarding his state of mind. So he wasn't even honest about his state of mind. And the trial court essentially believed everything that he said and put it into the findings of fact to determine the decision in respondent's favor. The trial court did not consider the egregious lies that the respondent repeatedly told and which were uncorroborated by his own witness. He claimed that he had a good relationship with the neighbors, yet was constantly getting...
That's a credibility issue. I mean, usually we defer to the hearing court, but I have a question for you. So what evidence did you put in to show that you didn't have any responsibility for the gates? What evidence did you put in?
Well, it wasn't our burden to show that it wasn't our burden to prove his claim under 740. We did prove...
No, I know, but I'm saying the court found otherwise. So what, if anything, did you put in contrast?
Well, we didn't have any evidence to put forward in that regard, but we did have evidence also to show that he was terminated for...
I'm saying there was a trial, right?
Yes.
Okay. And so usually you put one thing in and then you say, oh no, this is something else. So what did you put in to show there's no responsibility?
Well, I mean, that wasn't our main objective at trial. Our main objective at trial was to prove our affirmative defense, which was under Labor Law 744, which I believe we did. We showed that the respondent was fired for...
Okay, your time's up. Thank you very much. The next case is Etage Real Estate versus Stern.
Good afternoon, Your Honors. Bruce H. Letterman for the respondent. Judge Ed Gorin very properly determined that the individual defendants, David Jurasik and Michael Stern, who were the two owners, admittedly, of a company called DJJMS, which is their initials largely, did not come forward with any admissible evidence to rebut a prima facie case for piercing the corporate veil. The prima facie case in this situation is very simple and established by 4 simple things. 1, on April 20th, 2012, a holding company affiliated with...
Counsel, normally piercing the corporate veil is about showing domination, using the corporate bank, the corporation as your piggy bank, et cetera. There's a lot of classic indicia of what constitutes piercing the corporate veil. Judge Gorin did not discuss any of those in his decision. The only thing he focused on was a transfer, which was not even a transfer by the corporation which you're attempting to pierce. So how can that decision be upheld where it didn't even analyze any of the traditional indicia of when you get to pierce the corporate veil.
Well, actually, in a case which I handed in a slip for additional authority, BP 399 Park versus Pret 399, 150 83rd 507, this court in 2017 said, to the extent the court required a showing of fraud, the lower court erred.
I'm not talking about fraud, I'm talking about any of the indicia of piercing the corporate veil. Domination, control,
well, here,
et cetera. How was that shown on this record? And how did the judge grapple with that in his decision?
Sure, let me go through this. There was a piece of property acquired, 105 West
No,
50.
I understand there was a transfer of property, which was not a transfer by that corporation, but how can that transfer by itself, which was not a transfer by the corporation who's seeking to pierce, be sufficient by itself to give a piercing of the corporate veil?
Okay, I think that's pretty straightforward. That asset, which...
No. You know that's not straightforward.
Well, let him answer.
Thank you, Judge Scarpulli.
You and I are knowing each other a long time. You know that's not straightforward.
But I really do feel, if I can go through this, it is. If the property, there's a piece of property which is on DJJMS's balance sheets. To get a loan and a consulting contract with my client,
they don't own that property, right?
They have a...
They have an interest in a
they have an
company
interest.
so they don't own that property.
Correct.
Number one, right? So how did you show that they control the transfer of the property, and they don't even own that property, just themselves?
Because
they have an interest.
Well, it's very simple. Michael Stern signed the deed
with somebody else, not the other individual defendant, who didn't sign a single document, as far as I saw in the record, right?
Mr. Jurassic didn't, but Mr. Stern...
It's a summary judgment. That's the issue here. It's a summary judgment motion.
Right. But on a summary judgment motion, I again submit that we established a prima facie case by showing that there were financial statements saying that two people owned DJJMS, Mr. Stern and Mr. Jurassic. They were the owners. There's no question about that. 4 months after they signed the contract, Mr. Stern signs the deed as the transferor, where he's transferring a property on the balance sheet, the property that was subject to a profit participation.
DJJMS is not the owner of the property, correct?
But Mr. Stern is a principal, and if you look at the transfer tax, if you look at the forms that were submitted and sworn, Mr. Stern signed the statement to the City of New York as both transferee and transferor that the transfer was for zero.
And what about the other defendant?
The other defendant did not, but they are
Didn't sign a single document, and there's judgment against that defendant too, correct?
Yes, but I think Mr. Stern, there's no question about.
Okay, thank you. We understand your argument that the transfer by itself should have been enough to allow the piercing of the corporate veil.
I mean,
Thank you.
All right,
very
thank
much.
you, Judge. Judges.
The next case is General Insurance versus Piquion, which I probably mispronounced, but.
Good afternoon, Your Honors. May it please the Court. My name is Michael Krupnik of the Ryback firm. We represent the appellants, some of the healthcare providers in this case. Plaintiff respondents, the General Insurance Company, and its subsidiaries impermissibly sought to consolidate 32 separate claims for no-fault benefits arising from 31 different accidents. Each of these accidents involved different policyholders, different assignors, different witnesses, different healthcare providers, and different dates of accident. Indeed, the complaint does not allege a single fact that is shared among all, let alone most of the claims. As a result, the lower court was required to dismiss the complaint or, in the alternative, sever the claims. The lower court erred by doing neither. The complaint failed to comply with CPLR 3211A7 as well as CPLR 3016B. The complaint applies one cause of action based on stage accident and one cause of action based on material misrepresentation to all 32 claims on the basis that these claims were part of a common scheme or plan to defraud plaintiffs. However, they allege no facts, let alone any facts in detail, which is required for fraud, that there was a common agreement among the participants in all or most of the claims, that there was coordination among the participants, that there were common links or common circumstances or a common transaction or common ownership or a common contract among the participants in all or most of the claims. Dismissal was also required since the complaint improperly uses the vehicle of a declaratory judgment action to procure an advisory opinion. Next, the lower court, having declined to dismiss the complaint, was
Counsel,
required.
why is it an advisory opinion? Isn't this ultimately going to determine the rights of everybody as to whether or not there is coverage for the no-fault benefits at the end of the day as a result of this decision? So how is it an advisory opinion?
Typically, in a declaratory judgment action, the court is interpreting a provision of a contract.
But it's
or
declaring whether or not there's a right to coverage or not.
That's true.
That's a very
Yes.
concrete controversy that everybody wants decided.
Yes, but it requires an intensive factual analysis for each claim, which tends to be inappropriate in a declaratory judgment action, or tends to be
I mean,
uncommon.
that sounds more like your severance argument. It doesn't sound like a
Yes.
declaratory judgment action.
Yes, which leads me to my next argument, that in the absence of dismissing the complaint, the court should have severed the claims. This case involves two causes of action, staged accident and material misrepresentation, which each presents various sets of issues. The plaintiffs would have to go through these issues one by one in each claim over and over again, because almost without exception, the witnesses, policyholders, providers, and assigners are all different. There is simply no precedent for maintaining so many claims. Thank you, and we respectfully request that the court reverse the lower court's decision.
Almost dropped the door. Just shake it back.